think that we have contracts that don't work?
The contract is the starting place for remedies. Relationship doesn't cut it.
Right.
A contract drafted by a friend will not work.
But if you don't ChatGPT.
ChatGPT may not. But you need the expertise of a human being.
We need to talk about it. This is something that is plaguing the industry anyway.
Those little
Contracts are tailored for specific situations, not a particular contract that will be a one-size-fits.
At which point does someone say, this is the time that I now need to get into a
I
contract?
think this discussion should be from when the client picks up the phone and says, there is something I need you to do for me. That is where the conversation starts from.
Drafting contracts that actually work mean contracts that will envision every situation and be able to protect you in those situations during the lifetime of the project. You both have to figure out if the client can work with you and if you can work with the client.
The importance of communication is crucial.
Today we're going to talk about drafting contracts that actually work. Good afternoon from Uganda. Good evening, good morning, wherever you're watching us from. My name is Jacqueline Namanja, practicing architect in Uganda. Welcome back to our second episode of our podcast, a joint podcast, a partnership between the Construction Law Institute and the Uganda Society of Architects. We are excited to be here today. We are excited to have you. And we're excited to discuss what we're going to discuss about today. These are very important topics. I would like to introduce my partner from the Construction Law Institute, Anne.
Good afternoon, good evening, good morning from wherever you're joining us. My name is Anne Namara Msinguzi. I'm a lawyer and a member of Construction Law Institute and a director as well.
Yep.
And I'm happy to be here for this second episode.
Thank you, Anne. Thank you very much. And today we have a very distinguished guest, a special person to us back at the Uganda Society of Architects, Mr. President. Mr. President, we are very happy to have you here on our second episode. Please introduce yourself to our viewers.
Thank you, Jackie. Jackie is our immediate past president at Uganda Society of Architects.
President Emerita, as we call her.
Exactly. And so honored to be hosted today by the CLI Institute. I'm architect Kenneth Amunsimire, the current president Uganda Society of Architects and practicing architect in Kampala.
Yes.
So good afternoon, good evening, good morning, irrespective of the time zone you're in. We are pleased to be here with you in the second episode of the CLI and USA podcast series.
Thank you very much, Mr. President. So today's topic is, I think, a very important topic that needs to be addressed, especially in this industry in which we practice or partake. And it's the kind of thing that brings the legal and the technical together, and it disturbs us a lot. We find that, knowing very well that our podcast is designs, disputes and decisions, we want to be able to touch on those things that stem from our part, which is the design as the practitioner, get into maybe avoiding disputes or bring about disputes, and then the final decision. And today we're going to talk about drafting contracts that actually work. Actually, it's very important here because so many times we have contracts, or we assume we have contracts, and then somewhere during the project we realize that something went wrong, something went amiss, and it's not really working, either for the client or the practitioner, the consultant, or maybe for the contractor, because we are generally talking about the built environment right now, the built environment industry. So we want to be able to tackle and talk about that. And we're going to talk about the technical bit of it. We're going to talk about the softer bit of it. We're going to talk about the social bit of it, the context, the legal, all those things that actually come together to be able to deliver a successful project. So I want us to start where it really starts. And I think that comes down to the contract. I want Anne to just tell us, and do you think that we have contracts that don't work? What's your take on the issue of contracts, especially from your experience in the built environment industry? Because that's where your niche is. Tell me what you think about this issue of contracts that we use as architects, engineers, surveyors when you get to a project.
Thanks, Jackie. My view is two-pronged. we have what we call a semblance of a contract. We may call it a contract, but it's a semblance. Why do I call it a semblance? Because there are certain key terms that most of these contracts are missing. Yeah. Then we have situations where there are no contracts at all. So purely out of relation, the parties proceed. And we all know what happens when you mix relationship with business.
Right.
The end is not always so good. So there are so many parties to a construction project. We have the employer who is covered, we have the project manager, we have the contractor. And these people, the contractor is usually covered, the employer is always covered contractually, but then the consultant is always left out. There's always a gap in consultancy contracts, in Uganda at least. Yes, we have things that look like consultancy contracts. They have the parties, they have, maybe they have the duties, they have the money that is going to be paid, and that is it. And duration, that is it. They don't apportion risk. They don't speak about what happens if the project extends. They don't speak about what happens if the consultant can't be paid. So all those things are left to chance. So when those disputes arise, there's usually no contractual justification for the consultant to, no remedy for the consultant. And now we'll start looking for remedies at common law remedies in different places, and yet the contract is the starting place for remedies. Then the other scenario of relation. Hi, President, I need you to help me design or supervise my project. And then we start the back and forth.
Right.
We'll visit the site, you'll do the drawings, but there's nothing. Then at the end you're like, oh, okay, I've changed my mind, or I don't have money, or let me employ someone else, or you're too expensive. And yet you have done the bulk of the work. What's your remedy? Then we start looking at contracts that are implied through email, through different things, and that's just something that would have been avoided if everything was put down in writing. And I'm speaking from experience. I've had a couple of clients who come and they're in this situation, and these are very senior members of the built environment, and out of relation, maybe they've done work with this person, or maybe this
relatives,
client, or the client is a person or organization of good standing in society, so they lead you on and on and on and on and on. By the time you remember that for the architects, that there's a green book that truncates your payments and work, it's too late. The person will say, no, we didn't have any, you were just doing preliminary work, and yet preliminary work is also billed for. If you had a contract, you would provide that this preliminary work, this is the scope of the preliminary work, and this is how much I will charge for the preliminary work. So it's a little too late by the time you come to a lawyer, and we're just trying to patch up things and see how you can get a remedy. So I believe this is a very important discussion. But at the end of this discussion, we shall know what to do. As consultants, the consultants will know what to do, what to look out for. Relationship doesn't cut it. A contract drafted by a friend, please draw for me a contract, will not work if you don't know. ChatGPT may not may help you, but you need the expertise of a human being.
We need to talk about it. This is something that is plaguing the industry anyway.
To give you those little nuances. Yes, Chat will draw for you a contract, but it may need to be run through the eyes of a construction expert. Yes.
Right.
Yeah.
That's a very interesting thing you're mentioning, consultancy contracts, because most of the attention seems to be focused on the construction contracts, which, despite the challenges they have, end up being referred to quite a lot. And so we've had, for USA, which I'm most familiar with, we have the Green Book. And I've come to learn that over time, contracts are tailored for specific situations, and not a particular contract that will be a one-size-fits-all. And so I think we need to look at those unique circumstances and look at how we can address the uniqueness about them to make sure that both parties, or whichever party is involved, because it also happens these days that you have multiple parties to a contract situation, and some of them have ambiguous roles, and they end up creating chaos as the project is being executed. One thing to note is that contracts are tailored for projects, short-term endeavors. So they have a beginning and an end. And so when it's not well managed, you end up having endless conversations and difficulties. So how do we look at this limited endeavor in terms of time and resources and everything that goes with it, and make sure that we get the right context for it and understand each one's roles and responsibilities? In my opinion, that would be something that would enable us have contracts that actually work. When we understand exactly what we're getting into and being mindful of the various constraints we have at that time.
True. I agree with what you both have said, because I would want to actually ask Anne at this point, because she says, all this should have been there at the start in some sort of contract, or at least some form of record writing. I don't know, because like Kenneth has talked about, in any project, you'll find that there's the beginning, which comes to the appointment. But in our case, for example, let me just say the case of the architects, because that is what I know. There'll be the first part of that conversation, which many times, if someone is not sure where it ends and where the contract starts, someone will call you up and tell you, I need your services. And then, of course, you will say, okay, let's meet. Yeah, you meet and they'll tell you, my site is at this place. Clearly, when they start to tell you, I want this kind of structure, you need to even see the place. I want to know when you're having that conversation, because I think many times some people, after they see the place, they will decide if they want to actually go ahead with this project or not as the consultant, or if they decide to go on, they go on. So at which point does someone say, this is the time that I now need to start, need to get into a contract? Or would you advise consultants to have something already drafted up for themselves, of right from the beginning, when someone says, I'm in need of your services. You're like, okay, but I charge this for site. I charge this for meeting, for my time. And then, so that you actually don't have any losses anyway as a consultant, you're protected right from the start. And then when we get to those contracts, for example, and now this is based on what Kenneth has talked about. So there is that appointment, and then you get into the scope of what you're actually going to be doing. We get into being detailed about that scope, being detailed about your liability, being detailed about what the client is expected to receive or not. Yeah. So at which point would you say it's important for that professional to say contract right now before we go any further?
I think this discussion should be from the beginning, from when the client picks up the phone and says, hello, Jackie, there is something I need you to do for me. That is where the conversation starts from. You know, we keep saying, someone calls the lawyer and says, hello, counsel, a quick one. So from yes. So when the client calls and says, hello, Jackie, a quick one, yes, your guard should all be up, and you should be ready to ascertain what that quick one means. What do you want me to do? What is the scope of this quick one? Yes. So you need to ascertain scope from the beginning. Do you want me to go and look at the site? What do you want me to do when I look at the site? After looking at the site, then what? Do I prepare drawings? Do you want a preliminary design? What do you want me to do? But if you allow to be led on from the beginning, you have set the tempo for the relationship. So from the beginning, you should be able to ascertain the scope. From that phone call, from the email, from the WhatsApp, you should be able to ascertain what the client wants you to do exactly. You should be able to communicate these fees, and you can reduce it. It doesn't have to be a winding contract. You can have a contract that will govern the preliminary stage of this work. It will govern exactly what you want me to do. In the beginning, I want you to do A, B, C, D. So it's clearly spelled out that the billing is clearly provided for, and the duration is clearly stipulated. Then after that, when it's time for the actual work, phase 2, you can do an addendum and say, we are amending what we did at first to include these other items. So it defeats purpose when you're working and you don't know what exactly you are. Are you going to manage the project? Are you limited to the drawings? Are you going to do preliminary designs? So all these things must be written down from architect, a quick one. Yes.
And hold a second. That there have been instances where you as the architect, you know what you want to do, and your client has no idea.
No idea, because you're the expert.
Yeah.
Yes.
And so you end up promising to do something, and then you deliver it the way you know it, and the response on their side is that this is not like what I expected. How do you create that kind of balance? Do we need to have some kind of client awareness sessions so that they also understand what they're signing in for? Because certain times they are totally green about what they need, and sometimes they rely on agents, which agents may have certain interests and promote their interests more than what actually the client needs. So where does the client get protected in this, especially when they are from a point of being technically, I don't know the right word to say, but technically incompetent, if I could use that.
And to add on his before you even come in, that's exactly what I want to say is many times the client is calling on you because you're the one who knows what to do. And they are new to this whole building thing, but they want to get into it, and you're going to guide them. So many times the conversation will start by, this is what you have to do, and you have to do, and then you list it out for them. This is the process. So many times they don't even know what elevation, even the elevations, plans, schematics, what are those things? I don't know what those are. So how do you balance that? How do you,
Okay. So clearly there's no meeting of minds. At the end of the day, when you present your work to the client, and the client is like, this is not what I expected, or that is not what I had in mind, there was miscommunication from the beginning. So how do you nip this miscommunication in the bud? It's very important that even if you're dealing with an agent, Kenneth has mentioned dealing with agents, that you never get to see the client until the very end. It's very good to have these meetings. Meet with the client or meet with the agent, and at every stage, meet with them. See whether you are still, in the same path. But again, all that comes to what you agreed as your scope. If part one of your scope is doing something or designing or doing a drawing with the client will then appreciate and pay for, ensure that every stage you keep them posted, you keep them updated. This particular case that I was telling you about where there was no contract, so they do this design, the preliminary designs, and they keep sharing them back and forth on email. And the client, it was a hospital, a major hospital in this country. Client is like, no, there's no ramp. Please put a ramp here. Or the pediatric ward needs to be extended. Or there's no walkway, back and forth. Just unfortunately that at the end of the day, there was an issue of we didn't hire you. So if the scope is going to be, you are going to do for me a design which I must appreciate and a design that must work, that should be clearly spelled out in your letter of undertaking or your initial contract. And ensure that you keep them updated, and ensure above all that you have billed for it.
So just generally what you're saying is, because now that didn't really answer what he asked, how is the client protected? It talks about how is the consultant protected, which I think let's first, exhaust, and then we'll get to the side of the client. What you're really talking about is that it's very essential to ensure, any consultant, to ensure that their scope of the services they're providing is very, very clear and laid out. The mistake that many of us do, I have noticed, is we say, provide architectural services. Right? That is what we put. I've been hired to provide architectural services. We assume, in our heads, we know what architectural services are. But then until it gets to the point where the client then tells you, no, I don't like that design. Give me another option. That's an additional design now. Or I also want the interiors. Can you get into the interiors? No, I don't understand this layout. Or the 3Ds, where are they? Or, but you're my architect. Can you get into negotiating with the contractor and stuff like that?
Effective communication.
That is effective communication. But now what I'm trying to summarize is, that is effective. What I'm trying to summarize is what you have written down and presented as your scope of services should be very clear. That I am doing one design or two options. It will have 3Ds or not 3Ds. I don't know. For as long as it does not present itself, it should be clear that you will let the client know that is out of my scope. So in other words, don't go ambiguous and write, provide architectural services. What are those architectural services?
If you don't
detail what you're going to do.
Yes.
And the client says you didn't do what I wanted to do. It's on you really.
Exactly. And that's what we're saying, that we need to now let people know, because today we're talking about drafting those contracts that work for you.
Yeah.
And when we say that work, we mean that are protecting you as a consultant who is providing the service, but maybe also protecting the client. But we have, like you said, we have all these contracts already in place that are protecting the client, the contractor. So let's talk about the consultant, who is never really looked at. Drafting contracts that actually work mean contracts that will envision every situation and be able to protect you in those situations during the lifetime of the project. Yeah? So far we have talked about the scope
hold on a
part.
bit on that, because Anne talked about addenda, having addenda.
Yes.
I think addenda usually look at situations that may not have been earlier envisaged, and then because projects are very time bound. Many clients would come to you thinking that you're going to give them a solution yesterday, because they need
always
it.
come yesterday.
So,
Today for yesterday, right?
and I'm trying to get into the consultant's mind, trying to balance competence and also looking at using an opportunity while it's still hot. And so what are the things, sorry if I have taken this conversation in a different direction, but in the interest of time, before a consultant is deemed as someone who is taking too long to act, what are those things that a consultant would look at that either put a red flag on or give them a white flag to continue? At what point does it become, this is a sound project, we can continue, or this is something I should work carefully, tread carefully about when I'm dealing with this kind of situation?
I think this is, in my opinion, this is something that gets established in the very first conversations, before even your appointment letter. There's that appointment letter we always seem to never really mind about. When the client says, I've finally hired you to do this and this for me. That discussion, which talks about who the parties on the project are, the project description, meaning exactly what you're going to do, what your role is as the architect or the consultant on that project, what the fee structure is going to be, what the stages of payment or maybe of the service you're giving are, what the responsibilities are. I think that all happens at that very first or two, the very preliminary conversations before you finally agree and say, okay, we're going to work together. Many times this happens in the first or second meeting. The first meeting could, in my scenario that I know of, the first meeting usually be in the office or somewhere, and then you're like, oh, okay, let's meet on this day at the site. At that very time, you have gotten to that point where you seem to be almost in agreement that you will be able to take on this project. Yes? So now you've agreed to take that journey and go see that site. And at that point, I think that's when you start to put it down, that preliminary sort of what do you call it? Record requests, where you're saying that I will come to site for this amount of money, or this is my payment for my time, for my logistics, for this and that. And it's at that meeting, the first meeting, where she has to agree that indeed I'll take on those costs. They have to know that you're not for free. I mean, all this is time. So I think it's in that very first meeting where everything has to be laid out on the table. You both have to figure out if the client can work with you and if you can work with the client. There is also that. You'll end up being the kind of people who can't work together if you just take on any project, in my opinion. Yeah. And you have something to add to that?
No, I agree with Jackie. After the first or second meeting, really what you're going to do should be clear. The duration, how long is this going to take? Yeah. What happens if it doesn't, if because of factors out of the control of either party, it goes on longer than it should have? For instance, you are dealing with a project and there's this entire, confusion in the Middle East. We had COVID, now we have confusion in the Middle East. So the wars and all those unexpected events, the FIDIC calls them, 2017 calls them unexpected events. The previous FIDIC calls them force majeure. So what will happen? When you sit down, you're not going to expect force majeure. You're not going to expect a variation. You're not going to expect that something is going to go wrong somewhere. But by the time you have the second meeting, all those things must be on paper properly, such that if war breaks out in the Middle East, I am not bound to complete and that war affects the project. I am not bound to complete the project in a year.
In the original time.
Yeah.
Right.
But also things like, things we ignore, things like notice. Will the client assume, you said, how is the client protected? Will the client assume that you're not completing your work because of war or because of COVID? The contract should clearly stipulate that if something happens and the client needs to know, or the consultant needs to know, notice should be given at every stage. And that's also a manner of dispute avoidance, yeah? If I give you notice of everything, notice that, I think we're going to be delayed by this COVID-19, yeah? Or there's something that happened, the weather is just too bad. It has delayed us, and it was not foreseeable that during this time there would be a problem with the weather. So it has delayed the project, yeah? Or because of your too many variations, dear client, it has affected my program. I will not be able to complete. So when you communicate like that, essentially you are avoiding the disputes, yeah? But all that should be on paper, and as soon as possible. Not more than the second meeting, really. What is that you're talking about?
Talking about forever.
Yeah, forever. Yeah.
Right. So does that sort of answer you, Kenneth? Does that?
Yeah.
Or is there something else you're really trying to like?
No, it certainly answers that aspect. The importance of communication is crucial.
Yeah.
And also to know how that communication is sent out. Having a contract that spells out the reporting times and the expectations of that reporting time is really useful.
Yeah.
Because if you know what to report and you also know how to troubleshoot ahead of time, it really gives you a heads up on these things.
Yeah.
And it prevents situations where someone says they weren't notified, they weren't aware of what was going on. So, and I know it's for us, the consultant, sometimes you get so lost into the project that you forget that there's need to communicate. You want to look at the end and forgetting that there are stages along the way. So there are relationships to manage at each of those stages, and it's important also to know who the stakeholders in the project at that time are, so that if they can enable you get to decision making fast enough, you engage them instead of keeping everything to yourself. Like it happens sometimes.
Yeah, relationships are good, but they can also be a bad thing.
Allow me to digress a little bit.
Okay, let me.
The issue of relationships.
Yes, on relationship.
Yeah.
A client, you've done some work for a client before, and then they engage you for yet the same thing, maybe an additional facility, and because of relationship, you're like, let's do this. Nothing written. You go on, and this is a live scenario.
We have worked together before.
Yeah, until one day you're flipping through the newspaper and you see an advert for consultancy services for the same project. Yeah, you have been doing everything. You've had meetings, you've prepared designs, you've had Zoom calls, and voila, they're advertising what you are supposed to be doing. And when you get in touch with them, they're like, please apply. All this is relational. Yeah? Please apply.
But when you're in that situation, are you able to sue that person? I'm just asking. Even if it's you who forgot about because you were counting on good faith.
Yes.
Are you able
Yes, you are. But like I said in the beginning, it's not a walk in the park. So you will borrow from so many things. There's no contract. Okay, there's no written contract. So you will start looking at implied terms. You will start to look at what makes a contract a contract. Yeah. Yet if you had everything written on paper, you wouldn't be looking at what are the
implications.
Is there a contract? Is there no contract? You can now digress.
Yes, I just wanted to digress on the issue of communication. Something that we touched on with David in the first episode, that I find that this is something so many of us in the country, Ugandans, seem to have a problem with. I think it's something that should go down into the education system. Teach our people, our little ones, and communicate. Communicate at this stage. This is something that then will overflow into your professional life. Because communication indeed, that is what even gets down to you being able to have profound records on your project, because you found it important that I have to put this in writing. Much as I've had a phone call with my client, let me add it in writing to make sure that this is following our phone call, this is what we agreed upon. So you have the evidence that this happened. So my digression was, it needs to go back to education system. We need to talk about these things. We need our people to communicate.
Definitely. It has to be down to the fundamentals and as picked on as early as possible.
Yes, because even if you have the contract that actually works, if you don't follow the terms of that contract, it will not work. If the contract says communicate if there's a challenge, and you don't, chances are you will not have the remedy that accrues from communication. So communication is everything. Aside from records, communication is everything.
It's also important to understand the context of the client you're dealing with, because I've seen it happen a lot. Anne mentioned the issue about putting relationship first ahead of business, and it happens a lot. You find an organization needs a service, but because maybe you are a friend to
the boss,
or a procurement manager, you end up being asked for those services. Yet, in actual sense, those services are procured differently. So you end up committing yourself to do something without following the organization's known procedures, and you find you're fried because at the end of the day, there is no document to back you up, and there's nothing that moves with the organization values. So it's also important to understand the client context you're operating under, so that if someone wants you to do a jig for them, for the organization, the terms had better be clear, so that you don't end up, committing yourself too much.
But also, you said organization. There are so many people in an organization. You could, and the board or there's a committee that will need to give approval to your doing the work. So if Kenneth is dealing with Jackie and Jackie is just a friend, chances are high that the board may not accept your appointment. So that is why it is important, again, as I say, to have everything in writing. To have a document, if you're dealing with a company, properly endorsed by the rightful officers of that company. Lest you get into a situation, even when you're going to sue and the company is like, we didn't know you, we don't know you. You were dealing with an individual, you never dealt with us, where is proof that we instructed you.
And now I want us to, having really talked about scope, still protecting the consultant, there's something that we need to bring on the table as well, liability. The consultant's liability. And because many consultants don't have contracts on the projects or forget to, this, for those who actually have managed to have those contracts, might forget to have that liability cap, whereby you're assuming you will not be in that situation where you will be the fault or the reason that there's a problem on the project. And yet so many times it's actually the consultant. Variations, delay in communication, delay in giving the right drawings when something has come up and stuff like that. And so we I want us to discuss that situation. Professionals need to remember, that you have a liability. As soon as you take on a project, you have a liability, but you need to be able to say this is as much, or this is the weight on me. Be it maybe something that I think along the way, there are different ways some people have been doing it. They can probably tie it to the professional fee, saying if my liability will only be equated to the charge, my professional fee, that is what I give back to a client, right? Or that is what I incur as a professional. Or there's the issue of the PI, maybe, professional indemnity, or I have had there are people who take it as a multiple of the professional fee, stuff like that. Can we talk about the scenario? And have you experienced a scenario where the professional forgot to have that in the agreement and they had to incur quite a bit of money beyond what they're actually making on the project?
Yeah, and liability is twofold. Liability for what? Should be clear. And quantum. How much? So if, for example, my duty is to do the drawings, there's no way I can be liable for something that has gone wrong on the site. Okay? That is for what? Then how much, like Jackie has clearly stated, should be clear in the contract. When you're dealing with employer, contractor, especially in the FIDIC suite, we have what we call liquidated damages, and they're capped.
Right.
They're capped at a certain percentage. Yeah, you cannot levy liquidated damages in perpetuity. They are capped because the rationale for capping is that at the end of the day, it may not make sense if the liquidated damages are more than what I am being paid. That is for employer contractor, when there's liability on the part of the contractor. So also in the case of the consultant, it should be capped. First of all, it should be clear what I'm liable for. That is pegged to my scope, and how much, to what extent I am liable. And we have things like different types of damages, exemplary, punitive. They're usually capped in favor of the client, and the client will be like, I'm liable only to this extent. Out of this extent, I am not liable. But it should also work for the consultant. We've seen those one-sided contracts. For the consultant, and they're usually one-sided, by the way, because we also know that at the end of the day, it is the client with a higher bargaining chip, yeah?
Of course.
So, but we want a situation where the consultant also caps their liability to a certain percentage. And that is where the professional indemnity comes in very handy, yeah? I might be capped up to the extent provided for in my professional liability, in my PI, yeah? 100 million, whatever it is, it shouldn't exceed, and the contract should clearly stipulate that my liability should not exceed what is in the PI. Okay? My liability does not extend to damages that were not reasonably foreseeable. My liability is capped to a certain percentage of what I'm being paid. Yeah. Otherwise, you'll now go back to court to help you interpret what liability means and how much and who is liable. Yeah.
Kenneth, any experiences in that area?
None particularly.
You have been perfect on your projects then.
Not perfect, I must say. But, well, we have an interesting scenario in Uganda where we don't have well-informed clients. And so you usually have these situations come up when the client is well-informed and when there's a mess on the project, obviously. So, but we're heading there. Yeah. And it's important for members to be aware of this so that they, protect themselves in advance. Yes. Have the necessary safeguards that they need to have. But what Anne mentioned is really important. And I've had her mention about FIDIC. I think the engineers are really ahead of us in this, and we need to learn from them.
But the good thing though, and I'd like us to sometime later in the discussion talk about those different contracts that are available to us. The good thing though is now FIDIC does recognize consultant, not so?
Yes, there's a specific book, the white book, that governs relations. So it's a guide, because FIDIC is just a guide. Yeah, you may or may not adopt, but it's best practice used internationally. If you need funding from all these major donors, you can't run away from FIDIC. So they have a guide. It's called the White Book, and the latest edition is 2017, and it has tried to exhaust everything that should be in a relationship between a client and a consultant. We could borrow such best practices as we look towards developing ours in Uganda, a consultant contract, a consultancy contract. As we look toward developing one in the near future, can borrow best practices from FIDIC, from JCT, from NEC. All these are standard form contracts, and they all say basically the same thing on how this relationship is preserved. Yeah.
Very, very good. So far we've talked about scope, being very clear about scope. We've talked about liability capping. Let's get into IP rights. This has happened where a client will make you design. And this is for so many ignorant professionals, architects, engineers. Let me talk about architects. I'll not go into spaces I do not know, but I assume that other professionals will relate. Where a client will ask you to design. This is someone who has multiple sites. So you'll design for that site, and they will then keep multiplying what they've gotten for that 100 million. That design is what will happen on every other, but not necessarily with you being paid for that. And because of ignorance, many consultants don't know that that is actually against their IP rights. We need to understand that even our contracts should talk about intellectual property. Can we get into that space, Madame Legal? Where, yes, I need you to explain these things from your terms, because I can talk about it, yes, but I want you, as someone who's coming from the side of legal, talk about the fact that intellectual property belongs to the designer unless agreed otherwise. And I mean, I think we even had a Twitter space where you broke that down, but not many people. This is a whole different audience, I assume. So talk about how important it is to have those rights well clearly defined, that this is my property as a designer. And if you're going to multiply it, this is the implication, or this is what comes out of it. It is. Talk about that part of the rights.
We spoke about borrowing best practices.
Yes.
And that's the beauty of having everything written down. FIDIC 2017, the white book, clearly stipulates that the copyright or the intellectual property belongs to the consultant. But then they can give royalty-free licenses to the client or the employer. Yeah. That's what it clearly stipulates. So if you adopt those conditions of FIDIC white book, you are bound by that, unless you change
in
it.
Friendly terms of understanding, please. Don't assume everyone's understanding what you're saying, Madam Lawyer.
Okay.
Please speak to a layman now.
So if I make drawings, or designs or anything, the FIDIC book will tell me, if I adopt those terms, that they belong to me, the person who made them.
Yes.
Okay. So assuming that I have not adopted the FIDIC white book terms, and I'm looking at our copyright law of Uganda, the Copyright and Neighboring Rights Act, Cap 222, it lists several works, what amounts to copyrightable works, and one of them are drawings.
Awesome.
Yeah. And it says what Jackie has said. In the absence of a written agreement to the contrary, the copyright belongs
To the designer.
to the employer.
To the employer?
Yes.
Not the designer?
No.
In the absence of written agreement.
Oh, in the absence.
In the absence
Specific.
of a written agreement.
Oh, really? I
To
think
the
I had
contrary.
it backwards. Please educate me some.
In the absence. So now you see how it differs from FIDIC that says it belongs to the
Yes. Yes.
to the consultant. Now this one says in the absence of a written agreement to the contrary, the economic rights will belong to the client, the employee. What you will remain with something we call moral rights. What are moral rights? To acknowledge that you're the one who designed
Who
this
designed
thing.
it?
Yeah.
We give you the credit.
The credit. Yeah, the credit designed by Jackie and Kenneth Associates. Yeah, but the economic right will remain with the employer. In the absence, and this is what I belabored to explain at that express that Jackie is speaking about, there were so many questions out of it. People were not very happy, and I emphasized that you need to write down and say, look here, this is my work; it belongs to me. If I give it to you, because FIDIC says if you're to give them a license, then it is project specific. It is pegged to that project. So I don't want to see this drawing of mine replicated somewhere else.
Somewhere else.
Yes. So it is pegged. But if there is no agreement to the contrary, it belongs, and the contract is governed by the laws of the Republic of Uganda, then that work belongs to the employer. So you have to be critically careful from the beginning when you're drafting this contract to explicitly state who will own the copyright, who will own it, who will own the
Quite
intellectual
an
property.
interesting scenario.
Yeah.
I just want to throw a spanner in the works here. We have instances where there are projects that have been designed but not supervised by the same architect, and design reviews happen at that transition stage, and in the middle of those design reviews you have maybe variations coming up and that. So where do you draw the line? Who owns copyright for the final product? If the design, original
Has
design
been
came
tweaked.
from somewhere else and it's come now to a point of changes happening under the care of some other consultants. Because I've had a few issues being mentioned on this, where a client maybe wants to have drawings, and the designer architect is saying, no, you can't have these drawings. They belong to me. And the client is asking, but I paid you and discharged all my obligations to you. You have to hand over everything in its original form.
And that's the problem when you don't have any document showing who takes what and when. Again, we borrow best practice. FIDIC, the white book, says that if for some reason the architect doesn't complete the project, I mean the consultant, doesn't complete the project, then those drawings and all the works will belong to the employer. If there's no completion, it will belong to the employer. But it comes down to agreement.
I agree.
What have you agreed? If I don't finish, if you're just employing me, if this is my scope, what will happen? Do I still have the copyright in those works? Or they belong to you, subject to you recognizing my moral rights?
And just to be clear, the question you were asking about, was it in reference to situations where the change is happening because there's a different site going on, or it's for that very same site where
Same
the architect...
site,
Okay.
Same site, but different consultants and the transition.
And a transition is caused by very many things. Was there a dispute? Did the scope come to an end? Yeah, there's always a backstory.
So many backstories.
And so the contractor should envisage that backstory. And it's usually best practice in that situation for the employer to retain that copyright. Because he's going to use the drawings to finish. He's going to hire someone else.
Yes. I think if we haven't taken away anything today, what we're taking away is best practice.
Yeah. And write all the terms of the contract. Yeah.
Yes.
Everything under the sun that you feel should be provided for. And if you forget it, like I said, there's always, or if something else comes up, you can always amend. This is nothing cast in stone. It can always be amended.
Right.
Yeah.
So interestingly, our time is running really fast. We have quite a few minutes, but I want us to bring up something else that is also happening right now that maybe possibly isn't there in the contracts we've been using, because like he said, each of these contracts have to be tailored to the project. And as times change, if you're using a contract that has not been updated from a certain time it was last reviewed, then you will have to review it yourself and update it to work for you in that time. The thing that we're looking at right now is digital stuff, digital deliverables, digital work, ownership as well, which may tie a little bit into the IP, the intellectual property situation we're talking about. In this case, I'm saying you have to make it clear, because so many times you leave it out. We assume it's a given that I will send you work. You talked about emails and Zoom calls and whatever to have a project going on. But I think it's also very important now for you to include that clause which talks about how the client will be receiving their work. And in this case, are you saying you'll receive PDFs only? Are you saying you'll have CAD drawings sent to you? Are you saying you'll have the 3D visualizations? I think it's important that these digital files, who owns the digital files anyway? That's something else that needs to be very clear. What are you going to receive as a client? What will I be using to communicate the finished works or the finished drawings as a consultant?
I agree.
I open the floor.
I agree. It should be very clear who will own those, because we cannot hide from the fact that this is a world we're in. And the disputes of the future are going to come from such nuances. So we need to be very clear who owns this
and how they're going to receive this. I think it's very possible that situation where someone calls and says, send me the CAD drawing because I want my new architect to do this and this. The good thing is back home, we have this code of conduct or where you have a process of how you're supposed to switch architects. And if we keep to it, and you don't end up in DC. If you keep to it, then there is a well-explained and ethical transition between professionals. But if it's this kind where you're like, you tell the client, you call the other architect to give me the things, then the client suddenly, can you send me these files? I need to edit stuff. Since when did you get the skills to edit stuff? You're really just you're just passing on stuff to someone else. So also that has to be very clear, very key to be able to have a contract that actually works. And this, we're just talking about a few of these things that we seem to forget as consultants, and we forget to protect ourselves, right from the fact that we forget to have an appointment letter. That is our discussion today. So as we are closing, I just want Kenneth, is there something you really feel that we need to talk about that we have not addressed in this situation about the contracts that would work for a consultant?
It's just something about documentation.
Yes.
How it's common knowledge that people don't want to read volumes of information. And so there has been questions asked, can I have a one-page contract?
Just a one-page. It's very simple. And you have a template. So you have a template. You've done these things many times.
Like I just feel it.
But my understanding in this conversation is that it's not just the two of you that will sit down and write a contract that actually works.
Yeah.
You need to have many people involved, especially those that will guide the process better. There is always a temptation to follow templates, but there are certain times when you don't know what to anticipate, and someone else who would be a witness would help you look at that. So what I wanted to emphasize is the importance of having witnesses to contracts, so that it's not just a private conversation that each one may have different interpretations of, but have third parties that will ensure that the parties to the contract are able to fulfill their obligations. I also noticed that sometimes, and I think this is something we didn't talk about much, which is an elephant in the room, funding.
Funding.
How does the consultant secure that they'll get funding or get paid for what they have done? Because there are certain times when you engage and before you know it, you're down to scheme design, taking plans for approval, but not a single coin has come from the client.
Isn't that why we talked about the payment structure, that it has to be very clear in the appointment letter? Yeah.
And at one point, do you raise a red flag and say, I've not been paid, I won't continue?
A contract that actually works will detail the duration of payment. When are you paid? And after how long are you paid? The stages of payment.
Yes.
Yeah. If, for example, the contract says that within 14 days after presenting my invoice, I am paid, and the 14 days pass. What happens when you are not paid? Yeah. Contracts that actually work give the right to a consultant, to question the source of funding of the employer. So you say, you're going to pay me these thousands of dollars. What is your source of funding? Yeah? At any point, yes, and at any point during the duration of the project, the consultant should be able to say that, please, look here, I doubt your capability these days. You're taking long. You're paying me on day 13 out of 14. Do you still have money? What is your source of funding? Yeah? And so what happens if my payment doesn't come in within the stipulated 14, 28, 7 days, 30 days? What happens? What is my remedy? Do I terminate the contract? Do I suspend the works? What happens?
And I think these are things we should take very seriously. I realize that many of us have the fear to question such, especially when you're like, but we are friends. That will hurt our relationship. But if you are in business right now, he's putting up something that is going to make him money, and that is how you're making the money as well. So it's very important that when it comes to those things, if indeed it's a contract, it's written, it's in wording right there, you both have to honor it. That is what
situations where consultants have had to present performance bonds. So why shouldn't it be the other way around?
Yes, the other way around.
Why shouldn't the client also show cause that they will be able to pay for at least something that can be recoverable from the bank?
Yes.
There seems to be so much responsibility heaped upon the consultant, and the client isn't.
Yeah, it's very important for all of us as
I think both sides need assurances that what they're entering into is something that is going to be concluded within the time allocated to it.
That's the right definition of a mutual relationship. And you want to conclude for us what is important, or how to draft a contract that actually works. He mentioned that it's very important to have those other parties who are very good at what if? What if? What if? Because now you remember the what if. Yeah. What if the guy doesn't pay? Okay, but now what if it does? What if it dies tomorrow?
Yes.
Who pays me?
Yeah.
So can you conclude it for us, please?
Thank you, Jackie. Thank you, Kenneth, for a very insightful discussion. So contracts that actually work are drafted by somebody who knows what a contract that actually looks like, yeah? So it's not going to be, give me a template or cancel a quick one, yeah? A contract that actually works should be able to envisage everything that is needed for that particular project. Kenneth mentioned that it's not one size that fits all,
Right.
yeah? So a contract that actually works will consider every tiny detail, starting from the parties. We've had scenarios where somebody will come and say, but you're suing me for nothing. I didn't contract with you.
Yeah.
That is a non-existent party.
Yeah.
Yeah? And you start the legal dance from there. Yeah? The parties should be clearly stipulated. The scope, I can't overemphasize scope. Are you going to do designs? What are you going to do? Are you going to manage the project? Are you going to do all the above? Yeah? What are you going to be held culpable for? Now, what you're held culpable for is commensurate to the scope. Yeah?
Right.
Duration. What happens when there's an exceptional event? What happens if I need to know where the money is coming from? How am I being paid? How are we going to resolve disputes that arise? You know, we've not spoken about disputes, yeah? How are we going to avoid disputes from arising? What are the communication tools that are going to stop disputes from arising or that are going to avoid disputes, yeah? The notice periods. What happens when there are variations? All these things must be addressed. And only somebody who is skilled in the practice of construction law can be able to draft such a contract. So I would like to urge consultants. At times they say that, oh, that is very expensive. But at the end of the day, it saves you lots of money.
Yes.
Yeah, so I would like to urge consultants, as this is my parting shot, that do not enter into a project without sitting down with a qualified personnel to help you draft terms that shall govern the relationship between you and the employer to the tiniest of detail. That will save you lots of frustration and disputes in the long run. Thank you.
Thank you very much, Anne. So we've talked about professional appointments, scope of services, liability caps, professional indemnity insurance, digital deliverables, and ownership. In other words, be clear, be clear, be clear. Right. I would like to say thank you very much for joining us today for our episode 2 of the podcast, and we look forward to having you for our episode 3, where we'll dive deeper into the things that are plaguing and disturbing the consultants in the built industry. And what are we looking at next? Are we talking about those reasons that are never really talked about that get projects to fail? Thank you very much. And so we have been able to talk about how to draft contracts that actually work. It's very important for consultants in the built environment, in the built industry, to know these things and take them seriously to protect themselves in their professions. Professional appointments, scope of services, liability caps, PI, and digital deliverables and ownership. Most importantly, clarity, clarity, clarity. Thank you very much. Join us for our next episode, where we'll talk about the different reasons that projects tend to fail, the things that we never really talk about. We look forward to seeing you then next time on Design, Disputes, and Decisions.